let us, without further ado, I'm still recording. Yay, that hasn't told me I have 3 minutes. I am going to skip back. Hello to all of the people that have joined us for our 6 to 7. We have just been shooting the breeze about some of the past week's content, and I particularly wanted to run through the magical mystery tour, the unicorns and rainbows that descend around Section 18 of the Schedule 2 to the Competition and Consumer Act, because that has to be my favourite provision in the whole entire universe. And it really is all things to all men almost, and ladies. So if you want to check out the recording, that's fine. If you don't, that's also fine. We kind of had some fun just having a chat.
AJ, could I just ask ever so quickly, in regards to recording, will you be recording the follow-on from this for the assessment?
Oh, yes, absolutely, because I know, I'm not sure whether you're one of them, Kurt, but I know that there are a number of you that need to dash off.
I do, yep.
Yeah, so that's absolutely fine. And what I might do, Kurt, if you want to give it some thought during the discussions this evening, and if you have some burning questions in relation to the assignment, why don't you drop me a quick email, and I will check my emails before I start that discussion, and I'll be sure to answer any queries that you might have.
Okay, cool. I don't think I have anything in particular, but I'll think. Yep.
Okay. Was it you that asked that excellent question about the 1950 King's Bench decision?
Yes. Yes.
Yeah, that's great. I think you read a lot of people's minds on that, so that's why I hope you don't mind. I've posted it everywhere. I've posted it on Facey. I've posted it on Moodle. But that's useful. I think this is a really good unit for revising a lot of the stuff that you picked up in intro and stat inter. So this is a good unit to kind of move through and cement all of that, you know, stuff. And that's why usually with my first assignment for Contract B, I'll usually set something that does require people to think about, you know, the doctrine of precedent, or, you know, jurisdiction issues, and, you know, a little bit of, well, the questions you asked, you know, how do you look up cases? Do you need to hunt down a particular reporting series or not? You know, all of that stuff. It's useful to cement that before you move on, because the subjects that you get later on in your degree will kind of almost take it as read that all of that stuff's kind of worked in via osmosis, you know. So if you have it kind of, if you feel like you've had a bit of a refresher after this unit, it's kind of a good thing as you move through. So, yeah, if you have any other of that kind of excellent question, please feel free to drop me an email. And as I said, I'll quickly check my emails before we get cracking on that discussion. That goes for anybody, actually. If you have other questions that, you know, you want answered this evening, but you can't stick around, all good. Just drop me an email and we'll answer them as we go. However, this evening we get to discuss illegality, and what I will do is share my message screen. Sorry, this is the legislation we've been wading through. Gosh, I love that legislation. It's awesome. All right. Here, I moved the Word document over here. So can everybody see that? And is it big enough? Can I have a Y or an N? Oh, beautiful. Give me the thumbs up. That works. Beautiful. Okay. Lovely. So main items to revise. I'll do what I did in the beginning of just our informal chat, and I will quickly ask who's had a chance to have a look at the illegality materials, because it will just help me to, it doesn't matter if you have or you haven't, I just need to know where to pitch things. Can I have a Y or an N? And because I know that a lot of people are busy with the assignment, so I don't really mind if you, if you haven't had a chance. Yep, goodly smatterings of both. Okay, that's good. We will get cracking then. Void contracts. Now, were you thoroughly, sorry, I'm looking over here at your faces. Were you thoroughly confused by the end of this chapter? Or were you, for those that have had a chance to wade through it, how did you go by the end of the chapter? Were you feeling completely at sea?
I wouldn't say confused, but sometimes I think it can be sometimes difficult to determine the difference between illegal by statute and common law. Sometimes there's a bit of a crossover.
Yes. This has got to be, mistake is a classic area of contract law that really needs some help. This is another area that really needs some clarity. But the big, can I get a gut feel answer from people as to the big ticket item on how we distinguish between void contracts and illegal contracts? What is the main difference? And here I'm thinking in terms of consequence.
Crime? Illegal crime?
Oh, it might be a crime. It might simply be a contravention of a statute.
I found that most often than not, the ones that were void were the ones that actually had illegal terms in them. Quite often turned out to be voided, or especially like tort fraud ones. They were also declared void as opposed to necessarily illegal.
Okay, here's my handy dandy patented one-step method to distinguishing between void and illegal contracts. Illegal contracts have the consequence of ex turpi causa. Do you remember that horrendous Latin phrase?
Yeah, I just ended up calling it ex turpi causa.
Yeah, so does everyone. Otherwise, you sound like an idiot, really, don't you? Unless you're a student of Latin, in which case, my profuse apologies. Yes, that it goes. Illegality really goes kind of one step further, doesn't it? Because with void contracts, sometimes just depending on what's happened, you might be able to get some restitutionary assistance in recovering your money, and we'll look at that later on in this unit, restitution. There might still be some avenues of redress, but what is the what's the upshot of ex turpi causa?
Is it the court won't assist someone found in their cause upon action upon the immoral or legal act?
Yeah. Illegal involves the consequence of. And that is no assistance from the court. No recovery of any amounts due. You can't terminate for breach. You can't rescind. You can't get any specific performance or injunctions, no other equitable remedies. There's just nothing. The court's going to stand back.
So essentially, the biggest difference is once ex turpy cause is established, you're out. Whereas void contracts, at least there may be some remedies or relief issued, as long as obviously you didn't perform the whole contract.
Yes. Yeah. It's like, I don't know if you watched the video on this, but it's, you know, I've got that little graphic of a nuclear bomb going off because it's scorched earth. There's just nothing. You got nothing.
Well, when you think about it, the court can't support illegal things. Like, that wouldn't make sense, would it?
That's exactly right. But the problem often lies, and this is the difficulty, where there has been an illegal contract made, but it doesn't mean that the parties are what we call in pari delicto. It doesn't mean that the parties are equally guilty in getting into that illegal contract, that they did it knowingly to try and commit some kind of illegal activity. Often there'll be one party that unfortunately could lose a lot of money, but where you have a consequence of illegality, there's nothing that the court can do. The loss will lie where it's fallen. Yes? So equity, doesn't matter how unconscionable it is, equity can't step in and help. And that flows.
I think it does when property passes, though, and to a third party, to an innocent third party. I think that's the only time there's any sort of equitable relief. I think I could be wrong.
No, that you can't get that if the contract has been declared illegal. The consequence of ex terpia causa means that there's nothing. There's no equity, can't step in.
I suppose that would be the foundation of receiving stolen goods too, wouldn't it? Because you'll be the innocent third party that's received those goods, even though two other people have committed the illegal act of passing that property over. Would that be a fair comment, or?
So there will be no passing of property because there's
no passing of title. Yeah.
Been no passing of title. So illegality can stand to be a very blunt instrument. Yeah, very blunt instrument. Void contracts, there might be something that you can do, but illegal contracts, as you rightly say, I think it was Kathleen and Dwayne, both of you made the comment that, well, from a societal point of view, this has got to be the way things are, because once you have a judgment that a particular contract was illegal, you can't then soften the blow. Do you know what I mean? It has to be a blunt instrument. That's it. You've just got to, it has to be a lesson learned, I guess, and a bit of a deterrent to other parties that might find themselves in that position. So that's your really big distinguishing factor there. I'll get back to void contracts because I wouldn't mind having a very quick squizzy at where you're at with void contracts. So void contracts, two main avenues that a contract might be void, and that is under statute. Yes.
Statute and public policy.
Yes. Now, in terms of public policy, I mean, normally it's not.
That was the part that I found confusing because there's a lot of crossover between public policy and statute.
Well,
sort of, it depending on the context.
Generally speaking, I actually think that there's less of a problem here than there is when you're looking at the issue of illegality and statutory illegality and the mingling with common law there. In terms of void contracts, normally if a contract is to be void because of a statute, it's a reasonably clear process, because the statute itself will usually say, you know, contracts contracts are void. It normally expressly says in the statute itself contracts will be void. For example, in the ACL section, sorry, I'm looking at faces again, section 64 of the ACL, you know, where people try and exclude the consumer guarantees and stuff like that. Where they try and do that, section 64 expressly says any attempt to do that is going to be void. So it's not so hard. The issue with void contracts at common law and public policy, where the cragginess is with that, I think, is around restraints of trade. Did you have a look at restraints of trade? Yeah. So it gets a bit craggy.
I'm actually dealing with something like that actually at the moment. My new employer actually kind of didn't put that in the contract of the guy that he's just had quit, and now that guy is now actually trying to compete directly with us.
Yes. It's a really tricky one, because there's a lot of balancing involved, as you can imagine, between the parties, because there are a lot of employers that try and go too far and protect more than their legitimate interest. But then on the other hand, you've got to say to yourself, well, if you are an employer, you know, and you do employ this staff that gets a lot of personal relationships with your client base, they can just cut and run like that and take the client list with them, and basically they've got a leg up in business that really they've no proper claim to.
No, but isn't there something in the Fair Work Act about that?
You tell me, Carlo. I'm not an employment lawyer.
No, I think there is.
You are allowed to have restraints of trade, but they must be done in a fashion that it complies with public policy.
Yeah, no.
Yeah, it refers back to common law. It actually will look at reasonableness in the terms. Yes,
and that's your yardstick for much of this stuff.
It was found in Nordenfelt that it was just too unreasonable, the restraint of trade, so they didn't uphold that.
Nordenfelt, they actually did uphold the restraints so far as munitions were concerned. So far as the provision that dealt with any other competing business that...
he could still start up a lollipop shop if he really wanted to. They couldn't stop him from doing that.
That was the point, yes, Dwayne.
Perhaps I'm thinking of that one that's like tailor, dressmaker, and about 8 other different occupations. What was that one called?
Where what, sorry?
So it listed all of these different occupations that were restraint of trade, and the court found it was just too broad. They basically made him so he couldn't work at anything that he was good at.
Buckley and Tuddy. That was Buckley and Tuddy.
Buckley and Tuddy, that's just what they call a sterilisation case. Yeah. You can't take away someone's livelihood, and where the restraint tries to wander into that kind of territory, you'll often find it being the provision being struck down. As I said, this area of law involves a lot of weighing up exercises that the court has to do, and it's very difficult to draw too much assistance from any of the case law, because each case is so different and pretty much will, be determined on its facts. Yes, there are interesting principles that you can draw from the case law, but with restraints, it really will be a very particular, investigation of the facts of that particular case.
So I guess what I'm hearing is there's not really much precedent in this area.
It's hard to draw too much comfort from the precedent because, you know, it's more than likely that whatever you've got before you is not going to be something that matches up very nicely with the precedent that's gone before. And this is where I guess, you know, I've been having this discussion with a lot of students this past week with the assignment, you know. It is very difficult where, and this is just something that you need to get used to with your professional life, it's very rare that you will get a case that lines up with precedent on all fours and your job is a relatively easy one. It will always be a bit of a, you know, an excursion through a minefield of different precedents, some for you, some against you, and it'll be a matter of trying to make the best arguments that you can in the circumstances. And that's where you're thrown back on first principle. So if you guys get your first principle really clear in your mind, that's the thing that's going to really stand you in good stead. So in terms of restraints of trade, immediately you're going to be thinking of, well, you've got to look firstly as to whether the restraint is going to be reasonable in the interests of the parties, isn't it? So the person that's trying to enforce the provision has to make that argument. It's reasonable in the interests of the parties. And so what's the thing that you need to show there that you're protecting if you want to enforce one of these restraints?
You're actually protecting someone's livelihood?
Yeah, or what they call a legitimate interest. Yeah, yep. So that's
like a lot of them are just hoping that, like, it's like more a scare tactic. Like they're hoping that just the thought of them being in an employment agreement is going to be enough to make you never contravene it, because they know that they probably won't be enforceable. Like a lot of them probably won't be enforceable, but no one really ever wants to take it to court to find out.
yes, and that's often where, and you will get these tactics that they use where they use that laddered approach. I don't know if you've ever seen one, but they'll say, you know, you're prohibited from competing with the business for 5 years within a radius of 5 kilometres, or and then it'll be like a semicolon, or for 10 years in a radius of 10 kilometres, or for 20 years within a radius of 20 kilometres. So there will be a cascading drafting setup. And so clearly the intent there is, if it ever does get to court, we're going to try and enforce the scariest one. But the beauty of doing it that way, as long as you don't go overboard and include too many options and the court just gets sick of it and says the contract's uncertain, the beauty of that kind of thing is that you can, if there is some unclarity around what geographic radius you should be looking at, or what length of time, you can put in a number of different alternatives. But it does make it quite confronting when you're the person on the other side of things, and it does look quite scary. I'm sure that these things do get
There was a case in the readings this week too about that had laddered terms, and it produced 216 different variables.
Yeah, that's what you got to avoid, and that's where the court will just strike it down for being.
Well, it did. It explored does this make the term too uncertain? I mean, they did eventually enforce it, but I think they just severed a couple of the smaller terms out of it. But it was, yeah, I was like, wow, that's just a lot of variables.
Yeah, no, you can't go overboard there. But without doubt, they do get used as scare tactics for sure. So what the examples of things that might constitute a legitimate interest, I just want to move things along so we can get down to illegality. Things that might constitute a legitimate interest: goodwill when you're selling your business, preventing, you know, your client database getting ripped off, protecting confidential information, particularly, as the text says, where the employees formed a lot of close personal relationships with the clients and they are the human face of the company. That's the kind of legitimate interest that the court will be looking for in terms of enforcing this kind of stuff. If you can show that, the next thing is that it has to swing around, and the person that's resisting the clause has to show basically that it's unreasonable. So if you're going to enforce one of these clauses, it has to be reasonable in the public interest. So the one that's resisting enforcement has to show that it's unreasonable. So how do you do that? And this is where we were getting to things like what Talitha was talking about. You know, you got to look at the scope of the restraint, area, activities covered. This is where Luke was saying, you know, about Buckley and Tuddy, you know, where they were basically sterilising him from being able to earn a decent living given the skills he had. You can't go ahead and do that. Yes, so that kind of thing is going to be unreasonable in the public interest. So another one that we've already mentioned, Nordenfelt. This is probably the high water limit, and I think it's quite remarkable because that case is more than 100 years old now. But there was $1 million for the sale of the business. And they actually upheld the restraint as to munitions for 25 years without geographic limits. So it was a worldwide restraint from competing in the munitions business for 25 years. Why is that? Look at how much he got.
They considered it to be sufficient consideration for a promise.
Yeah, this is where I said, you know, this is where the court, it's a real weighing exercise, and it really will turn very much on the facts that are brought to bear in evidence. So in that case, $1 million in 1894, it's probably like $2.3 billion in today's dollars or something. I mean, that's an enormous sum of money for 1894.
And AJ, even to this day, armaments companies are one of the biggest businesses in the world. I guess they always have been.
Yeah. So they can afford to throw around this stuff. Okay, so that is the main one in terms of contracts contrary to public policy and therefore void. You can try and sever the clause, obviously, and have the rest of the contract upheld, but whether you can do so will depend very much on how integrated that clause is with the rest of the contract and whether they can unpick it from the rest of the contract and get rid of it. The other two main common law reasons for declaring a contract void and as for being contrary to public policy are ouster and clauses prejudicial to the status of marriage, but these two are almost not really worth discussing, are they? They're so marginal nowadays. Yeah, there's just not. Unless anyone has any burning thoughts on contracts prejudicial to the status of marriage. Okay, so illegal contracts.
Actually, I think there actually was a case, I think in 2013, I think it was, where a bloke who was married had a mistress and was paying her off. And it was deemed that it was prejudicial to the marriage because he died and she wanted to enforce the contract. The mistress did.
Yes. Unsure whether that reflects the common mores of society.
Yeah, I think, but that was the only one that I could come across that it would even come close to that sort of aspect of prejudice to marriage.
Given that more than 50% end up in the divorce courts anyway, I'm not sure that it's quite the bastion of society that it was.
Vivian spotted it too, Ashton and Pratt.
Yeah. Yes, I actually felt sorry for. It's a very unfortunate case if you read the case. Okay, can we look now at illegal contracts? Illegality at common law. So that's not directly relevant to the tube problem that we've got for this evening. Can you just run through a few of these categories of contracts contrary to public policy for me? Who haven't we heard from tonight?
So is that committing a crime, defrauding revenue, the administration of justice, public officials?
Yep, on you, Sean.
Yep. National security, sexual immorality, and
Yep,
that's it?
yep. Yes, indeedy. They are contracts contrary to public policy. I'll put that in there, eh? That'll just make it nice and clean. Look, it's useful for you to know about these, but as I said, it's not directly relevant to the tube problem. So, and as you can see by the nature of them, they're not the kind of contract that you will encounter in practice very often, and I certainly never encountered any of those. The result is obviously, as we were talking about at the beginning, extirpation. So that's a really serious consequence there. Again, and just to hammer that home, if you have the result of extirpation, you're not going to get anything. Yes? Illegality by statute. Now, three kind of varieties here. Someone tell me the first kind of illegality by statute.
Express.
Yes, who was that?
The one who's always talking, can't shut up, me.
Okay. All right, Dwayne, time for you to let others have a go, mate. Let's talk about express illegality. Someone tell me about Baird and Magripolis. Can someone give me a little potted history of Baird and Magripolis?
Yes. Sorry, I think that's...
Oh, sorry.
No, sorry, I think I'll cut someone off. You go, Vivian.
Okay. So the defendant leased land in Queensland, somewhere in Queensland from the Crown, and then he subleased it again to two Greek men who could speak very little English. And in the contract, there was a date by which they had to, I think, perform. Till June, sometime in 1923. But these men had to take the English test and to become naturalized. So they became naturalized, in March 1923, But they didn't pass the English dictation test.
Yeah.
So they were the plaintiffs, the two Greek men were the plaintiffs in the case. And they sought to have the agreement enforced, but the court would not accept because according to the Aliens Act, there was this something about leases to aliens restriction act. It said that no one could enter into an agreement with anyone who was an alien and who hadn't passed the test. So eventually they lost the case because the court rendered the agreement null and void.
Yeah. Yes, the contract was void. Yeah. So the act itself said it was not lawful to enter into any agreement for any lease of any parcel of land with any alien who has not first obtained a certificate he is able to read and write from dictation words, and any such agreement should be null and void. So it expressly said if this happens, the agreement's going to be void. Express illegality, yes? Fairly simple.
Sorry. And unfortunately, both men had spent a lot of money developing the land.
Yes. Yeah. Yes, they had. And this is where I say, you know, the consequence of illegality, often it's not that the parties are concocting some dastardly thing together. Often there will be a real loser out of this. And it's a very drastic result because they're not going to get any help. What's the next category, please? Glenn, did you want to jump into this one?
Yeah, sorry. So implied is the next category.
Yep, implied. So do you want to go through just what is implied illegality? What does the court look at when you're looking at whether or not something is impliedly illegal?
So it's the object of the act. So if the object of the act can't be achieved without that contract essentially being unenforceable or illegal, then it probably is. Yep.
So you go through the object of the act, the purposes for which it was enacted, the wording of the prohibition itself is often a giveaway, isn't it? And this is where you get that really minute focus on legislative drafting. I tell you what, I wouldn't be a legislative drafter if you paid me $1 million a year. The minute scrutiny that your drafting gets in this kind of a scenario is fairly extreme. So what did they? Yes, I know, Kathleen. What a job. So I'm just thinking of the Yango pastoral case here. Can someone give me, flesh this notion out for us of implied illegality? Just the potted history of Yango. Who wants to jump in?
The bank was trading without a license and got hit for, I think, $10,000 a day.
Yes. Well, there's a sting in that tail. Yes. There was an act that prohibited carrying on a banking business without the proper approvals and authority. Yes. And what had happened? Can you remember?
The court decided they shouldn't be punished per an account, they were just punished per a day.
Yes, the court had the question was whether this deal that they had done with some borrowers, so the borrowers had borrowed money subject to a mortgage and some guarantees, and then they had defaulted on that arrangement. And when the lender tried to enforce the securities, that's when the defaulting borrower tried to argue illegality, so that obviously they could get out of having to pay back whatever they wanted, they were, being told to pay back. So you can see why this argument crops up, because it might allow you to avoid your obligations, yes? Kind of get out of jail free card. So what did they say in Yango? Apart from, there was that issue about $10,000. How did that factor into the court's reasoning, that $10,000 a day penalty in the legislation? What did they say about that?
Wasn't it something, I found it a bit confusing, but it was something about that the penalty wasn't for each specific thing that they had done wrong. It was just one overall penalty. And so they used that reasoning to determine that they should still be entitled to get repayment from the lenders.
Yes, precisely. Very good. So they said there was that one $10,000 stipulation per day, regardless of how many contravening contracts that they actually concluded, how many inappropriate finance contracts they concluded. There was just that one overall penalty per day. And they said if the legislature had intended to make all of that business's contracts illegal, you would have a whole heap of unintended consequences, wouldn't you? Because it would involve other contracts that the business had engaged in that would really leave a lot of people out in the cold that had done nothing wrong. So they said things like the business's employment contracts would be illegal, and its other contracts for services that it contracted. So they said it didn't actually, the legislation didn't impliedly make all of that business's contracts illegal. It just meant that it shouldn't be carrying on that business of a financier without the proper approvals. Yes? So in that circumstance, that particular contract wasn't impliedly illegal. Yep. Okay, Pretorius, though, that's a very different matter. And who can tell me about Pretorius and Muir?
I can.
Okay, hang on a second. Is anybody else able to? Dave, Jade, April, Kathleen, Jamila, Melody. No takers? Okay, go Vivian.
Okay, so the plaintiff sold, he supplied some therapeutic substances to the defendants who would not pay now. And unfortunately, he did this. When he did this, he was contravening the Therapeutic Goods and Cosmetics Acts.
Yes.
The New South Wales Therapeutic Goods and Cosmetic Act 1972, Section 13 of the Act. So he now sued the defendants, and then the court said he was in contravention of Section 13 of the Act. So it was unfortunate because he could not be paid.
Yeah.
So the defendants who wouldn't pay for the goods that they received actually got away with their behavior, with their thought, if I say so.
This is why I say it's a blunt instrument. Yes. But what was the big message in that though? Why was the court look, I've done the wrong thing here. The court was concerned about public safety.
Yes.
That was your issue.
Yes. Yes. The court said the whole act was actually directed to implement it as an implementation of a policy to protect consumers.
Yeah.
Of goods. Yeah.
Yeah. So this is why I say it's almost like a deterrent thing, isn't it? This is the really bad stuff that can happen if you
yes.
If you contravene. So, okay. The last one is where it's not express, it's not implied, but nevertheless, no express. No
With an
implied.
illegal purpose.
Ah, lovely. Who was that? Demi? Was that Demi? Oh, who was that? You're right. Exactly. Doesn't breach an express or implied prohibition, but nevertheless, there is a norm that is interpreted as being the underlying substrate in the Act. The Act sets up a norm of public behaviour, and whatever's being done in terms of this contract contravenes that norm of behaviour. Yes? And that is your third and final way that you might find that your contract's illegal under statute. I do love the Fitzgerald and Leonhardt case, and if we had endless buckets of time, I would take you to, in fact, I'm going to. I would encourage you to paddle about in the case law every now and again, especially where you get a beautiful decision by one of the great gods of the bench. He's just fabulous. And if you get a chance to read Kirby's decision in this, you'll understand why he is so well respected. So I would encourage you, if you've got 5 minutes, go ahead and do that. But we have a, yeah, good on you, Vivian. It is kind of amusing. So the problem that we have, the scenario is rabbit pelts, yes? In the little animated video. What happened, the silly person that has come to the lawyer, whatever his name was, I forget what his name was here, decided that he was going to farm rabbits to sell the pelts. And so he contracted, before he'd even set up the rabbit farm, he contracted to supply 1,000 pelts per year for 3 years to a wholesaler. So he's trapped himself into this contract to supply rabbit pelts, and then he finds out that rabbit farming in Queensland is illegal. Yes? So the fur he wants to back out. The fur wholesaler says no. He made a deal. He needed the pelts as he'd on-sold them for the next 3 years, wanted them delivered, wants specific performance. Here's his name, Peter. Has the contract to deliver pelts, but his farm is in a region where rabbit farming is illegal. So let's get cracking. Can someone give me like a 1-sentence issue statement? He is stupid, yes. Yes. What's the magic word the marker's going to be looking for here?
Illegal by statute.
Yeah. All right. Rules. Well, we've just discussed the rules ad nauseum, so I'm not too worried about that. So what are you going to be telling the marker here? How are you going to start? He wants to avoid the contract. You can see clearly that the problem is telling you, it's driving you down the path of discussing illegality. So how would you structure this?
Look, first I think it's got to be in one of the 3 areas we just discussed.
Yes, because it's illegality by statute. So you're going to have to show the marker that you understand all 3 areas, aren't you? Yes. So you're going to say, you might want to start off with some general discussion about what illegality does to a contract. Perhaps.
Maybe start with discussing the first element by showing, look, you know, in the Muhammad case, it was illegal to buy and sell linseed oil without a license. You could make that that element very, very clear. To show how the court frowned upon it, and then you could look at the case that Peter is what he's done. Is he's trying to do something that is actually expressly prohibited by statute. And
hold on. Is it expressly prohibited? What is being supplied under this contract? Is it live rabbits? What's prohibited by the Act?
Ah, right. Yes.
What does the contract
okay.
actually
Rabbit
say he
skins.
has to farm them? Like, he could get them from somewhere else.
Lovely.
Like,
and I can't see you. Who's talking?
oh, Talitha, sorry.
Oh, Talitha. Okay,
Like,
sorry. All I
he
get
might-
on my screen is like this. I get 6 people and that's all I... Sorry, Talitha.
That's okay. I was just going to say, like, without seeing the contract, like, he could have a contract to supply them, but it might not say that he has to grow them. Like, he could buy them from someone somewhere else and be like the middleman and then on-sell them. So there's no reason to say that he can't still supply them. He might just have to buy them from someone else for more money.
Yes, and that is the exact quandary I think that he's found himself in, because he has contracted. The facts just tell you that he has contracted to supply 1,000 pelts a year for 3 years. So it's simply a supply agreement and not supply of live rabbits, pelts. So there's your immediate issue. It's not going to be a case of express prohibition, but nevertheless you would want...
I might be going out on a bit of a limb here, but it sounds like his best chance might be in equity.
So we're talking about, Luke, we're talking about illegality under statute, and here you are only looking at whether something is or is not illegal. Remember, if something is illegal, then equity cannot step in. So your first task is to work out whether or not it's illegal, because if it is illegal, that's the end of the day.
Yeah, gotcha. I said I'm going out on a bit of a limb, but it just sounds like what Talitha has just described is that it's just a bit unreasonable that he has to go and get the rabbits from somewhere else, lose all that money, and they didn't really intend for it to happen, you know.
But what about, you know, the whole issue of, well, as the solicitor in the actual, in the animation says to him, maybe next time before you lock yourself into a contract that's legally binding, you'll go and see a solicitor first. Yes, it's unfortunate, but I guess my word to you as law students is you will not be able to find a solution for every client. Sometimes it is unfortunate, but that doesn't mean that there will be a remedy for that person at law or in equity. And that's something that
some people just do that silly things and they just have to pay for 1,000 rabbit pelts and move on with their life.
Yes. What would likely happen in my gut feel on this would be he'd be held to the contract. He would just have to either have the choice of trying to locate the pelts and on selling them, or he would have to just breach the contract and pay the damages. Unfortunately,
can I just go out on a bit of a limb myself here? This almost sounds like a wartime case we delved into a wee while back about a poor guy who was going to supply a metal or an ore to a company, and war broke out. The price of the ore went up, and he was stuck with the contract because he still had to get the ore at a higher price.
Yes. Unfortunately, there's not always going to be a solution, and particularly, you know, sometimes it is unfair. I mean, with those cases we discussed in the prep for this, particularly where you've got an issue of contractual illegality, often there will be a very harsh result in it somewhere for one of the parties. But you can't assist that. Here, though, I think what you'll find is the contract is not illegal, but nevertheless, there is still a harsh result and a lesson learnt for one of the parties, yes? So we've kind of cut our discussion a little short. I just wanted you to touch on, do you think that this might have been impliedly illegal? Can I have someone's gut feel on that? Could it be impliedly illegal?
Can I just jump in and say I don't think so either in some aspects, because I think that the law in Queensland stipulates farming live rabbits in Queensland. I do believe they are allowed to be in Queensland dead. There are numerous places around Queensland where you can actually source rabbit meat and rabbit carcasses.
Yeah,
so you could get around it.
Yeah, and that's what I was hoping that a Queenslander among us might have a gut feel on. And yes, the main legislation that prohibits keeping of rabbits is the Biosecurity Act. And the whole point of the Biosecurity Act is avoiding the diseases that come with pests like rabbits, as cute as they are. And so the object of the legislation is to prevent disease that's getting spread, particularly myxomatosis and stuff like that. Not myxomatosis, the other disease. Myxomatosis is the one that kills the rabbit.
Calicivirus.
The other, yeah, they do spread disease, and so pelts and rabbit meat are not going to spread disease. So I don't think it would be impliedly illegal either. The other thing is, if you look at the third category of illegal due to contravening the purpose of the legislation or the norm that gets set up, if you go and read your Leonhardt case, like I suggested, I don't think that you would find any relief for Peter there either. Does anybody have a contrary view to that? Did anyone think that this might actually be illegal? Feel free to argue the point. No?
Can just, if, for example, he wasn't selling them to make akubras, he was on selling them, and that eventual purpose was illegal, is that where he could try and then argue under that third of in furtherance of a legal purpose? Like if there was something like, say, akubras were illegal, and he was selling them to some like black market akubra dealer, that would then come under furtherance of a legal purpose because the eventual purpose of it is illegal under statute.
Yes, that's actually a really good observation. Well done. Yes, the Equus case is the case I think that you may find some clarity with there. So with the Equus case, and let me just check the spelling for you so that it's Equus Corp, E-Q-U-E.
2 U's.
Equus Corp case. In that case, there was a prohibition on raising money by way of selling interests in a scheme that had been prohibited without first issuing a prospectus. You have to be able to, when you're going to raise public funds from a scheme, you need to, if it comes under the Corporations Act, you need to be able to inform your purchasers, and that's why you have to have your prospectus. They did, set up a scheme, no prospectus. The question was whether a financing contract that gave the purchasers the money to buy into the scheme, whether those contracts were illegal. So it's a little bit like your example of the Akubra hat being illegal. Yes. So in that situation where that arrangement without a prospectus was illegal, the facilitating of that conduct by giving people money to do it, that was a breach of the norm that the Act had set up. Yes. Great example. Lovely work. Well done. That was complicated. Yeah, it kind of is. Everyone happy? I guess those people that have to run, bye. Bye, and I'll check my emails. Shall we segue into our discussion on the assignment?